Welcome everybody to Political Science 110, Objective D Notes. As you know, this objective deals with a bunch of Supreme Court cases, so let's not waste any time and let's get right to the first one, and the biggest one, and maybe the most important Supreme Court case of all time, namely Marbury v. Madison, 1803. The background to this case is interesting. William Marbury was supposed to be a judge, but James Madison, who was then Secretary of State, didn't bother to deliver the document because his boss, Thomas Jefferson, didn't want Marbury to become a judge. So Marbury sues Madison and said he should have gotten this document delivered. The case goes all the way to the Supreme Court. Chief Justice John Marshall, our first and many say greatest Chief Justice, found that Marbury was correct, but the law that Marbury was suing under was not supposed to be written in that way. So he strikes down the law, and in so doing, establishes the power of judicial review for the Supreme Court. Judicial review is this notion that the Supreme Court has the ability to strike down acts of Congress as unconstitutional. That is not in the Constitution. So the main power of the Supreme Court, that it's able to strike things down as unconstitutional, was given to itself by the Supreme Court. It is not in the Constitution. The significance of this is obvious. Now, with judicial review, the Supreme Court, it becomes an equal branch of government. And all of the other court cases we learn about in this video and in the rest of the course and in your life all stem from the power that the court holds to find things unconstitutional as established under Marbury v. Madison. Question. Take a moment and explain the significance of judicial review. Do this in at least a full paragraph. Go ahead, pause the video, answer the question, and then resume when you are ready. This brings us to our civil rights cases. These are some of the most famous cases in the Supreme Court history. They are very, very important to American history, and as such, they will lead off our discussion today of the Supreme Court's landmark cases. We start with Dred Scott v. Sandford, 1857. Now, Dred Scott, who is pictured there, was a slave, and his owner moved to a non-slave state. Specifically, they moved to Indiana. When they are in the free state, Scott then claimed that he was free. He actually then, his owner dies, and his owner's widow claims Scott as property. Scott sues the widow and says he is not property because he is in a free state. Case goes to the Supreme Court. In one of the most infamous Supreme Court decisions, the Supreme Court found that no African American could be a citizen. Furthermore, Scott was not free in any case, because after you are a slave once, regardless of where you are taken to, unless you are specifically freed, you cannot be freed. You cannot be considered a freed person. This is widely seen as one of the Supreme Court's worst decisions in the history of the country. It was so bad that it continued to fuel the buildup towards the Civil War. Note the date for Dred Scott. That's 1857. Just a few short years later, 1861, the Civil War will start in earnest. Civil War was America's most violent conflict, and one that we still see repercussions of today. And the Dred Scott case was a key piece in pushing the country towards war. Moving onward, after the Civil War, we go to Plessy v. Ferguson. Now, that man pictured to the right of your screen is Homer Plessy. Homer Plessy was 1/8 black. That means he was just one of his grandparents was black. The rest were all white. In Louisiana, they had a law saying that black people and white people would ride in separate train cars. Plessy challenged this law. He rode in the white train car. He was arrested and fined. Takes his case to the Supreme Court, arguing that racial segregation violates the 13th and 14th Amendments. However, the Supreme Court disagreed. They found against Homer Plessy and said that indeed, separate but equal is protected. This very famously begins the era of Jim Crow laws, where all throughout the country, most notably in the South, separate facilities for what were then called colored people and white people were established throughout the country. Separate bathrooms, drinking fountains, swimming pools, and most importantly, separate schools, which leads us to our next case. Brown versus Board of Education of Topeka, Kansas, 1954. So this is 60 years, roughly, after the Plessy decision was passed down. A number of families in Topeka, Kansas, of which the Brown family was one, sued because their children, in order to get from their neighborhood to the school that was designated the colored school in Topeka, Kansas, their children had to walk through a dangerous train yard where train cars would be pushed against one another and moved around and shunted back and forth, and the children had to cross this train track area to get to school. This is an obviously dangerous situation that Topeka was not willing to put its white population into. But the Browns sued, and the other families sued. In a landmark decision, Plessy is overturned, and the significance of this becomes there's a strong legal basis for the civil rights movement. Brown versus Board of Education will kick off the civil rights movement on a legal front in a way that could not be done otherwise. From 1954 onward, for about the next 20 or almost 30 years, the fight for equality between African Americans and white Americans would be waged in the streets, in the courts, and in the schools, and we have now arrived at modern American society, where certainly we do not have equality between races, but we are a far way away from the situation that was in existence prior to Brown versus Board of Education. Question 2. Trace how the Supreme Court has changed its opinions regarding civil rights issues over the past 2 centuries. What do you believe caused this shift? And does this matter? Are these changes significant or not? Take a few moments, answer that prompt, and when you are ready, restart the video. And we're back. Now I'd like to spend some time talking about the freedom of religion cases. The Supreme Court has ruled on freedom of religion many times. We're going to only highlight a handful of cases now. First, and probably most significantly, the Lemon v. Kurtzman case. The background on this is as follows. There were laws set up in Pennsylvania and Rhode Island that gave some financial assistance from taxpayer dollars that would go to religious schools. In both of these cases, they were Catholic schools, and the laws would give some kind of funding to parochial education. Some parents in Pennsylvania and Rhode Island sued, of which Lemon was one of these parents, and they went all the way to the Supreme Court. The Supreme Court found that there needs to be a test for questions relating to religious establishment. First, does the law have a secular purpose? Remember, secular here means non-religious. So does a law have a purpose that is not specifically one dealing with religion? Second, are the principal effects of the law neither advancing nor inhibiting religion? So when the law is in effect, will it help a religion, hurt a religion, or neither? And lastly, and this is the broadest of the three elements of the Lemon test, does the law foster what is termed an excessive government entanglement with religion? That means, does this law just make religion and the state too close to each other? And if any of those questions are answered in the wrong way, then the law can be struck down. The court found in Lemon that the state support for parochial schools is wrong, and that the government should generally stay out of religious affairs, and religious elements in society should generally not try to impose their will through the political process. Lemon v. Kurtzman goes a long way towards establishing a very clear delineation between church and state activities. Moving into the modern era, I'd like to discuss one of the most hotly contested Supreme Court cases in the past few years, namely Burwell v. Hobby Lobby. Here's the background behind this. As you know, President Obama initiated a major healthcare reform law that is known as the Affordable Care Act, ACA. We typically call it Obamacare. Under Obamacare, everyone had to be offered insurance. Now, the Hobby Lobby company, the Hobby Lobby, by the way, is a retail store that sells hobby supplies, like craft supplies. The Hobby Lobby was owned by a family, and they said that in their stores, their health insurance coverage would not offer contraception as one of the elements covered by their health insurance. Contraception, obviously here being the drugs used to prevent a pregnancy. The court found in favor of Hobby Lobby, saying that corporations can restrict access to contraception coverage on religious grounds. This has very wide significance, and we aren't totally sure how significant this will be, as it has only just been recently passed. First, this initiates this idea that corporations are kind of people, that the Hobby Lobby has a right, and a constitutional right, to religious freedom. Not the people who own Hobby Lobby, but the corporation itself. So this case kind of treats corporations like they are people. Furthermore, these corporations may be able to place other restrictions on employees in the name of religious freedom. We aren't sure if that part will come to pass or not, but it could be argued that since they can restrict contraceptive coverage, they might be able to restrict other activities that their employees engage in and argue that it is their religious freedom. Question 3. Why is a separation of church and state so critical in American society? Moreover, what particular elements of our history and our traditions support the notion that separating the church and the state is important to us as a people? Take a few moments, answer that question, and when you are ready, move on in the video. And we're back with probably the most important and lengthiest piece of this entire presentation, the freedom of speech and expression cases. Now, we're going to begin with one of the biggies, Miller v. California, 1971. Miller was not what you would call an upstanding citizen. He was conducting mass mailings of pornography. California had a law saying you can't just mail porn to people. This case goes all the way to the Supreme Court, the question becoming whether the sale and distribution of obscenity is protected by the First Amendment. Essentially, can you just mail out what you want to mail out? And the court found that the First Amendment does not protect mailing obscene materials. People have a reasonable right to expect to not be presented with things that are generally considered obscene. But this leads to the question, what does generally obscene mean? So the Miller test was developed. First, and you have to look at all three of these questions here. If any of these questions are answered the wrong way, then you could really consider something obscene. First, does the work appeal to what is known as a prurient interest? Take a look at that word there, prurient. Prurient means, does this appeal to just your basest, lowest instincts? Or is this material designed and made to be something that appeals to people's higher order thinking and reasoning capacities? Second, does the work offensively depict sexual conduct specifically defined by state law? Some states had specific sexual acts and specific sexual conduct that was simply illegal. And putting that into a photographic or video form would have also been considered obscene. Lastly, and this is the broadest one of all, does the work lack what is known as serious literary, artistic, political, or scientific value? This is what we call the SLAPS test. The SLAPS test has been widely applied to a variety of works. This is where we get to differences between things such as a portrait of a nude woman in an art museum, not obscene, as opposed to a picture of nude women on the internet, obscene. Does the work lack real value? And who decides this value? The Supreme Court or local jurisdictions. So local jurisdictions, cities, counties, states, can decide what is obscene and what is not. So the Miller test is very important. It has broad implications for what we can consider to be obscene material in today's society. Moving on to Minersville v. Gobitis. Now, this is not about obscenity. This is instead about forcing compulsive behaviors on people who don't want to have that done to them. Here's the background. First, during World War II, in the build-up to World War II, the Nazis also persecuted Jehovah's Witnesses. Everyone is familiar with Nazi persecution of Jews, but Jehovah's Witnesses were also considered an inferior group. And they've started to make Jehovah's Witnesses salute the Nazi flag. When the Jehovah's Witnesses in Germany refused, they were rounded up. Many were put into concentration camps. So in America, Jehovah's Witness leaders in America decide they are not going to have their children salute the flag of the United States because of what happened in Germany. And they were protesting that and saying that it is their religious right to not have to be forced into an expression of love or solidarity with the United States, that they have higher ideals, that the Jehovah's Witnesses, first and foremost, are here to worship God, then secondarily, they're also American citizens. The court took up the case of the Gobitis children. The Gobitis children were Jehovah's Witnesses children in West Virginia who were forced to salute the flag, and they refused to do so. If you look at the letter that's on this slide here, it's the last part of the letter written by Billy Gobitis. Billy Gobitis at this time was in the, I believe, 4th grade, and he was writing his teacher a note saying, I don't want to salute the flag, and here's why. And the note still exists, and there's a copy of it there on the slide for you. The Gobitis children, Billy and his sister, were expelled from school because they wouldn't salute the flag. The Gobitis family sues. Case goes all the way to the Supreme Court. Supreme Court finds that schools have a right to force you to comply with a wide variety of things, including saluting the flag, because during this time, the build-up to World War II, national unity is the basis for national security. And because that's true, schools can force you into saluting the flag because in wartime, it's important to have a unified nation. This set off a firestorm throughout the country. First, many people did not even know that Jehovah's Witnesses were not saluting the flag in schools. Widespread violence broke out against Jehovah's Witness families in the early 1940s. The Gabbitas children's expulsion stood. They were essentially thrown out of school. Now, a few years later, this case will be overturned by another case, West Virginia v. Barnett. So the current state of the matter is that you cannot be forced to salute the flag, but for a few years you could. This is one of the examples of a time when the Supreme Court goes against itself and goes against its own ruling. This brings us to West Virginia v. Barnett, 1943. Same state, West Virginia. They still required the flag salute, and in a new case brought by a different group, not by Jehovah's Witnesses, but just by individuals who did not want to salute the flag, the Supreme Court decided that they were wrong in the Minersville case, that states cannot force you to salute the flag because diversity of opinion is one of the most important parts of our democracy. And you'll see with many of these freedom of expression cases, what we're really getting down to here is some people think really unusual, sometimes unpleasant things. And since they do, and since they have a right to think those things, they have at least a limited right to express ideas in a variety of forms. One form of expressing an idea is refusing to salute a flag. And in West Virginia v. Barnett, 1943, the court found that, yeah, you cannot just force people to salute a flag. We can have differences of opinion, and that does not actually threaten the country. It rather strengthens the country. All right, moving on to Schenck v. U.S. This is 1919. So 1919, as you know, is during World War I. Schenck was a socialist. He was a guy who thought that wealth should be distributed equally amongst people. He distributed all these flyers to U.S. soldiers who were recently drafted, saying resist the draft, don't show up for the army, because basically what is happening is the capitalists in America are forcing this war, World War I, onto us, and we need to not allow the people with the most money to make the calls in society. On the right there, you see his pamphlet that he passed out, and he was arrested for that. He was arrested under what is known as the Espionage Act. He was essentially arrested for working for the enemy. The Supreme Court upheld that conviction, and the Supreme Court said that the First Amendment freedoms depend on the context. So during some times, such as during a war, it is not okay to go around saying you want a socialist revolution and you don't think that the soldiers should show up to go fight the war. During a war, that is not okay. The First Amendment is taken in context. Beyond that, free speech is not limitless. There are some restrictions on what you can say and what you can communicate. The really important piece of Schenck, though, is that it establishes what is known as the clear and present danger test, where we will determine if your speech can be restricted if it poses a threat, a specifically clear and present danger. So the classic example of a clear and present danger is yelling fire in a crowded movie theater just to get people to panic and run out because that amuses you. That kind of speech is a clear and present danger. You're not allowed to just cause panic for the sake of doing so. So if your speech can present a clear and present danger to another person or a group or the nation, in Schenck's case, then it can be limited. So this is one of the examples of how speech can be limited based on what the speech is and when and where you say it. Moving on to Texas v. Johnson. That is Johnson right there in the picture. Johnson was a communist, and he burned an American flag as a protest against President Reagan. Now, Texas had a law on the book saying you are not allowed to burn flags. Johnson was sentenced to a year in jail and a fine, and he sued, saying that burning the American flag is a reasonable act of protest. And the case goes all the way to the Supreme Court. Supreme Court holds that flag burning is protected speech. And here's why this is significant. Many Americans, a large majority of Americans, think that burning the flag is an awful act, and doing so is offensive, deeply offensive. The Supreme Court said it doesn't matter. It doesn't matter if you're offended. It doesn't matter if your feelings are hurt. What matters is we need to have the right to express any opinion, even if that opinion is very unpopular. As long as that opinion does not threaten someone else, then we should be able to express any opinion we wish. And burning the flag is definitely expressing an opinion. Texas v. Johnson was followed up a few years later by U.S. v. Eichmann, 1990. Eichmann and some other people were protesters, and they were arrested for violating the Flag Protection Act. Here, the Supreme Court found that you cannot prosecute anyone for burning a flag, and it strikes down the Flag Protection Act. Flag burning is expressive conduct and cannot be prosecuted. So the Texas v. Johnson and U.S. v. Eichmann cases are the flag burning cases. Here are two Supreme Court cases specifically saying burning the flag is an allowable act of protest. This moves on to something that is even more offensive to many people than burning the flag, and that is burning a cross. Now, we are all familiar with the Ku Klux Klan's terrorist activities where they would burn crosses on the front lawns of African American families, civil rights workers, etc., throughout the South as a means to intimidate and harass. In Virginia, and this is in 2003, in Virginia, three guys, one was named Black and two other people, were convicted of violating a Virginia law against cross burning. Now, these guys did not burn a cross on someone's lawn. They burned a cross in their backyard, seemingly just as an act of protest. Now, they were Klansmen, and this was at a Klan activity, but they were not burning the cross on someone's lawn as a direct act of intimidation. But the Virginia law isn't written that way. The Virginia law says that any cross burning is what we call prima facie evidence of intimidation. Prima facie says specifically that no matter how you do it, where you do it, why you do it, cross burning is intimidating. And as such, it is illegal. Now, this case gets a bit complicated, as some Supreme Court cases do. The case goes to the Supreme Court. The court found that the state can ban cross burning. So you have a right as a state to ban cross burning. But, and here's the important difference here, you cannot simply establish any act as prima facie evidence violating the First Amendment. Here's why. You cannot just say that anytime you do X thing, it is illegal. Sometimes we have to do things in order for a variety of reasons and motivations, and there needs to be room in society to do things that are perhaps very offensive, but sometimes done for the right reasons. So, for example, if you were making a movie in Virginia about the Ku Klux Klan, you might realistically want to burn a cross to show what these people used to and still do. Under the Virginia law, as it was written, even making a movie about this where you burned a cross as a prop would have been considered illegal and intimidating. And that's the part of the law that the Supreme Court struck down. So the Virginia law had to be altered. And this is significant because burning a cross is almost the most offensive thing you can do. even the most offensive things can sometimes still be done under certain circumstances. And that's the importance of Virginia v. Black. Now, we're going to rewind the clock here to Tinker v. Des Moines. Right there, you see the Tinker children. They were high school students in 1969 during the Vietnam War, during the height of the Vietnam War. They decided that they were going to wear black armbands to show support for a truce that was brewing in Vietnam. When they wore these armbands, and you can see them there holding up the armbands, they were suspended from school. The school said that wearing the armbands was disruptive to the school environment, and it was against school policy. Their parents sued the school district. Case goes all the way to the Supreme Court, and the Tinkers win. The Tinker children won the case. Their suspensions were struck from their records, so it looks as though they were never disciplined. And this is a very significant case. This tells us that your First Amendment rights don't stop at the schoolhouse doors. Just because you walk into a school building doesn't mean you give up all of your First Amendment freedoms. Beyond that, political speech in schools can be limited, but only where it is shown that that political speech would substantially interfere with the school. Wearing armbands does not substantially interfere with the school. Now, staging a walkout or a protest probably would, but simply wearing a shirt, an armband, something like that, that is not substantial interference with the school, and as such, the First Amendment has to be protected in the school setting. All right, let's write this stuff up. Now, we just learned about a bunch of interesting cases. Take some time with question 4 here. Think about these related questions. Why is the expression of unpopular or distasteful opinions a protected part of speech in America? Basically, why do we allow people like the Ku Klux Klan, like flag burners, like radical communists? Why do we allow them to keep speaking and saying these ideas that are both unpopular and, for many people, fly in the face of what it is that America should be about? And the follow-up to that is, how would our country be different if this were not so? Take a couple minutes. Write a whole paragraph here. Support your answer with at least one case from this past section. Go ahead, pause the video, answer that question, and then resume when you are ready. All right, let's move on to freedom of the press. We're going to begin in 1929 with the fascinating case of Neer versus Minnesota. Neer was kind of a dreadful individual. He was anti-Semitic. He was racist. So he published this little tabloidy newspaper where he would go on these racist rants and talk and talk and talk. And then he would also sometimes publish a few stories about public officials being associated with the mafia. Minnesota shut the paper down because they said it published obscene materials. The anti-Semitic racist pieces were obscene. This is an important piece. Neer sues Minnesota and says, you cannot just shut my paper down for what it might say. And the Supreme Court agreed. Supreme Court found the government cannot shut down newspapers for something that it might publish. The government doesn't have the right to go to a newspaper publisher and tell them what to publish or not publish. Doing so, by the way, is called prior restraint. Now, there are some examples when prior restraint is allowed. For example, you are not allowed to publish military information. You cannot publish things that are obscene. You cannot publish things that might incite violence. But other than that, you can publish a lot of things. You are not the government is not allowed to tell newspapers what to publish or not publish. That is simply not the government's role, except in those few cases that we just mentioned. Interesting end to this story. So Near, like I mentioned, publishes all of these stories about public officials, city councilmen, people like that, being associated with the mafia. 1934, Near ends up dead in a mafia bar in Minneapolis, Minnesota, because apparently he uncovered a mafia connection very deep. So though this guy was kind of an unpleasant fellow, he ends up getting killed by the mafia for something entirely different. This brings us to New York Times versus Sullivan. Now, this is a fast forwarding in history to 1964. This is a fascinating story. New York Times carried a full-page ad in 1964 to get people to donate money to help defend Dr. King against legal charges. Now, here's the problem. The ad had several inaccurate statements about the police force in Alabama, and the police force sued the New York Times, saying that is libel. You are saying we are these awful people and we're not, etc., etc., etc. The Supreme Court takes up the case and ruled that the New York Times is correct. The New York Times said you could not sue us for libel because we didn't know that the things that we were printing in that advertisement weren't true. And this is a big deal. This shows that in order to sue someone for libel, the press organization has to know that it is committing libel with malice or reckless disregard for the truth. Basically, this sets a very high bar for libel. It is very difficult to sue someone for libel. You have to show that they are really out to harm you in order to sue successfully for libel. And this protects a lot of newspapers from publishing a lot of really unpleasant things about people. This is why we can have stories about public officials having extramarital affairs and things like that. Unless it can be shown that the news organization was committing reckless disregard for the truth, then they can pretty much publish that. So New York Times v. Sullivan is a libel case. All right, question 5. Question 5 is, many Americans don't list the freedom of the press as one of our most important freedoms. Do you agree or disagree? Pick one of those two cases and support your answer. Take a few moments. When you're ready, resume the video, and we'll continue on. Now, this brings us to our rights of the accused. Beginning with the biggest rights of the accused case, Miranda v. Arizona. Here's the background. Ernesto Miranda was arrested for rape and kidnapping. And when he was arrested, he was interrogated without a lawyer for a few hours, for 2 or 3 hours. In this interrogation, he confessed. He said, yeah, I did it. I kidnapped this woman and raped her. And his case goes to trial, and he was convicted and sentenced to 20 to 30 years in prison based on this confession. However, his lawyer argued Miranda was not aware of his rights when the police arrested him. And as such, he could not have given that confession in a constitutionally protected way. And the Supreme Court agreed. Miranda's confession was unconstitutionally obtained, and the court said that Arizona had to retry that case without that confession. This gives rise to this notion that all of us have seen on TV and in movies, that when you are arrested, you have to be told your rights prior to being questioned. If they don't tell you your rights, your arrest can be thrown out. So that's why we call those the Miranda rights. Now, Miranda ends up not exactly leading a very happy life after this. Arizona retries Miranda, and he is again found guilty of the crimes he was originally found guilty for. Even without his confession, there was enough evidence. He ends up serving 11 years. Then when he gets out of jail, he has legal troubles the rest of his life. He's in and out of jail constantly, But he's, at this point, kind of a celebrity. He has this really famous Supreme Court case named after him. And he used to carry these little cards with the Miranda rights on them, and he would autograph them and sell them for $1. And a lot of people had him. He was a minor celebrity. He ends up being killed in a knife fight in a bar in Phoenix, Arizona, in 1976. So it comes to a tragic end. But in his pocket, after he was killed, they found a bunch of those Miranda rights cards. Kind of an interesting side note. Now let's talk back about schools. New Jersey versus TLO, 1985. TLO are initials of a student. So it's supposed to be kind of anonymous here. And she was a student in a New Jersey high school. Now, she was caught smoking in the bathroom. Now, when she was caught, she was searched. And school officials, it was an assistant principal, found cigarettes, marijuana in little baggies, a bunch of dollar bills, and a list of students who presumably owed TLO money for selling them marijuana. So she was charged with possession and expelled. However, she gets a lawyer. The lawyer sues the school district. Case goes all the way to the Supreme Court, with the question being this: does the exclusionary rule of the Fourth Amendment apply to searches conducted by school officials in public schools? Essentially, if you're searched on school grounds, do you have to does the principal have to have a warrant to search you in school? And the Supreme Court found that no, the exclusionary rule does not apply to searches conducted by school officials. School officials need a very low level of suspicion to search a student, that student's belongings, that student's person, etc., and that essentially you are not fully protected by the Fourth Amendment inside of schools. This is due to the fact that schools have a special need to keep students safe, and this need trumps the Fourth Amendment. So here's another example of how the Fourth Amendment, one of your Bill of Rights amendments, one of your fundamental liberties, can be limited in certain circumstances. Bringing us to Mapp v. Ohio. Now, this is one of the more colorful stories of this lecture. Mapp was a woman living in Cleveland, and Cleveland police officers received a tip that she might be harboring a fugitive and she might have some drug paraphernalia in the house. So the police show up at her door, and she says, no, you can't come in, I won't allow it. So they said, oh, we'll come back with a warrant. They left for a few hours, came back with a fake warrant, broke down her door, arrested Mapp, and searched the house. When they did not find the fugitive. They did not find any drug-related contraband, but they did find some pornography. In 1960, in Ohio, a possession of pornography was illegal, and Mapp was convicted of possession of pornography. Mapp sues Ohio, and the Supreme Court takes up the case and rules in favor of Mapp, saying, look, you can't first use a fake warrant, and even if you have a real warrant and you go into someone's house and find other evidence, then that cannot necessarily be used in court against you. This is known as the exclusionary rule. The pornography that Mapp was in possession of was in a small, locked container. And the Supreme Court said that was not part of a warrant in any case and could not be used against Mapp. So this really establishes your right to not have your private home searched whenever police feel like they should search your home. Question 6. What changes do you believe should be made to either support or weaken the rights of the accused in modern American society? We haven't had a real big case related to this for some time. Support your answer with at least one case and write no less than a full paragraph. Take a few moments, do that, pause the video, and then resume when you are ready. Moving on to our final section, other notable cases. Now, we'll begin with DC versus Heller. The background of this is that in the nation's entire history, there have only been a handful of Second Amendment cases ever heard by the Supreme Court. And the Supreme Court had never, until 2008, ruled whether or not the Second Amendment protects your right to own a handgun. Well, in 2008, it did. 6 residents of Washington, D.C. filed suit against Washington, D.C., saying that the Washington, D.C. law about owning handguns violated the Second Amendment. Supreme Court takes up the case and finds for the first time in the nation's history that the Second Amendment does protect your right to personally possess a firearm, and you can use that firearm for lawful purposes. This includes the purpose of self-defense in your home. So this means that, yes, all along we've all been kind of saying we are allowed to own guns and we can protect our houses with these guns, etc., etc. But what DC v. Heller tells us is that, yes, the Supreme Court agrees. The Second Amendment protects your right to own a firearm. And moving on to our final case of the day, Roe v. Wade, 1973. Roe v. Wade is probably the most controversial Supreme Court case in the history of the court. This is the abortion case. Now, there have been other Supreme Court abortion cases as well, but this one is the one that originally found that women have a right to have an abortion. Jane Roe, which is an alias, wanted an abortion, but due to very strict laws in Texas about having an abortion, she couldn't get one. She sues, and this case goes to the Supreme Court. The court finds that there is a right to an abortion, but this right is balanced. The state has an interest in protecting the life of unborn children and in protecting women's health. So the right to an abortion exists, but it is limited. And this right exists under the 14th Amendment, basically saying that you have a right to privacy. Medical decisions, such as the decision to have an abortion, is essentially a medical decision. As such, it is protected. Originally, under Roe v. Wade, the Supreme Court said that you could have an abortion during the first trimester of a pregnancy. Future cases have gotten rid of that trimester system, and instead, we now say that you have a right to an abortion until the fetus is considered quote-unquote viable, meaning it will be able to live outside of the mother on its own with modern medical technology. That is about 7 months into a pregnancy. So Roe v. Wade, hotly contested. You can see on the image there that you have 2 abortion protesters, one on either side of the issue. Every year there are protests and debates and controversy, and Roe v. Wade was the case that kind of kicked all of that off. When Roe v. Wade was passed, a large number of states, something like 20 or 25 states, had laws on the books making abortion illegal. And in one stroke of the pen, the Supreme Court got rid of all of those state laws and said, yes, the right to an abortion does exist. Leading us to our last question. Question 7. Take a look at these cases we've discussed. Which is the most important and why? Give me a paragraph on this. Dig in. Really think this through. Of those 15, 16 cases, which one strikes you as the most important? Take a few moments, answer that, and I'll see you in class.